Good morning. Welcome to another edition of Legal Access. We're going to be talking about premises liability here today. That's our topic. If you have any questions about that, what that means is if you get hurt on somebody else's premises, are they liable for it? What can you do after that? What should you do after that? What should you not do after that? So if you have any questions about slip and fall, trip and fall accidents, anything along those lines, today is the day to call and get those questions answered. On the dais here today to answer your questions on the panel, let's go ahead and use panel instead. From the McGuire Law Firm, we have both Ian McGuire and Brittany Jones.
Hey, Dave.
And from the O'Neill Law Firm, Rick O'Neill here with us today.
Happy holidays, everybody.
Yes.
Happy holidays, Rick. It's always great to have Rick with us, and he's been on here so many times, but Rick has a unique background in that he started off in law enforcement and spent a number of years doing that before proceeding to law school and becoming a lawyer. So it gives him a unique perspective, I think, especially when we talk about topic today, premises liability and how it affects injured people, but also from a defensive standpoint. I know Rick's firm, as well as doing premises liability and workers' comp, he also still does criminal defense work, don't you, Rick?
Yes.
And so if you have any questions on any of those topics today, give us a call at 843-848-8080. That's 843-848-8080. But it's good to have Rick back with us today. And it's always an interesting topic this time of year, Dave, especially with holiday parties and all that's going on.
Holiday parties, you got some slick weather out there with some rain, hopefully not ice or snow later on in the season, but we did last year, so you just never know what's going to be going on. But if you have any questions about this, don't wait to the very end of the show. Call us now. We'll get those questions answered as far as premises liability is concerned. What would you say to potential clients if they called you up or if they did not call you up, but if they're out there thinking about the fact that it's like, well, I got hurt on somebody else's property, but I don't know whether or not I should go to a lawyer because I don't know if it raises to the occasion of me needing an attorney. What would you say to them?
Yeah, I always say call sooner rather than later. There's never any harm in asking. Consultations are free, so you may as well call, go over your situation with somebody and see if it's worth something, worth pursuing. Just because you call doesn't necessarily mean we're going to take that the attorney that you talk to is going to take the case, but we'll certainly let you know, one way or the other if it's something that we do think it's worth pursuing or not. And if it is, then the sooner you have an attorney on your side, the better. So.
Yeah, and if you're on the other side, I remember when my kids were young and there were kids playing in our backyard and one of the kids fell off the swing set and he broke his wrist or his arm and I told his mom, listen, this is our insurance, call, and it's no problem. And she wouldn't do that. But the point is, that's what we have insurance for.
That's right.
And it's if you have homeowners insurance and somebody gets hurt on your property, you might want to check with your insurance company if that happens and let them know what's going on. But it's something that hopefully can get worked out because you've had insurance. The people that don't have insurance that are really should be worrying, because then if there's a suit, it's actually going against their assets, right? As opposed to just insurance.
Yeah, and that's why you have insurance. Like you said, you've got insurance there for a reason. And so when that situation arises, you may as well use that coverage that you've put in place.
Yeah.
And these type of claims, they really fall in to their dual claims, because most premises liability insurance has a no-fault medical payments part of the policy, and then the rest of the policy, and the main meat of the policy, is a fault-based. You're the claimant, you have to prove negligence. But there's two parts usually of the insurance policy. So even if you've been hurt on someone else's property and they weren't at fault at all, it may, look into it, because at the very least you may be able to get some of your medical bills paid.
Yeah.
Now, if you are somebody who was hurt on somebody else's premises, if it's a business or a public entity, what's the first thing that you need to do to make sure that you move forward with this? I mean, contact the management or the owner at that point?
Yeah, it's always a good idea to let the premises know that the injury occurred. Also, always a good idea if obviously you want to seek medical treatment that you need first. But if you do have the opportunity to take photos of whatever it was that caused you to fall, caused your injury, it's a good idea to go ahead and start documenting those things. And so I think some people might feel a little funny about doing that, but truly it's expected that documentation is going to exist one way or the other. So, and a lot of businesses will also have or offer some kind of incident report, and if they don't, that's certainly something that you can ask about to create sort of a paper trail, a documentation of what happened.
What if you get hurt on the premises and you go back a day or two later to take pictures and the hazardous condition has been cleaned up or fixed, whether it's a crack in the sidewalk or a root or something like that, or a hole that's been filled in? How are you going to beat that defense that it's like, hey, you took pictures, there's no hole there anymore?
Yeah, that's certainly something that can come up, and especially when we're talking about, earlier we mentioned like the weather, or if the surface was wet or icy or something like that, and that condition might not last for an extended period of time. So having those photos would be great, but if you don't, and in the situation, the condition has changed when you go back to take photos, usually there's some way or other, that we can document or find documentation of the condition that existed that day. But just because it was fixed does not, a lot of times people want to say, well, they went back and fixed it, therefore they knew it was dangerous, that should be held against them.
Yeah.
And that, we call it a subsequent remedial measure, and that actually cannot be used as evidence against a business at trial. But that does happen, so it is important that the sooner, once this happens, the sooner you get an attorney, the sooner you get that documentation, the better.
And that does come up where we'll have clients who'll say, look, they fixed it. It's that's proof. And public policy will want people to fix things, and we don't want people not to fix things because they think if they do, it's gonna be an admission of some sort. So that's why I know you want to explain why that would not be, in most cases, something that would come into a trial.
In South Carolina, is there any kind of percentage of fault? Can the defense say, well, he should have looked where he was going before falling in the hole, or tripping over the sidewalk or something like that?
Yeah, one of the common number one defense in a premises liability is it was an open and obvious danger. If you would simply have been watching where you were going, you would have seen that there was uneven pavement, a hole in the pavement, some type of hazard. Now, when you get into especially shopping situations, stores and so forth, the stores are encouraging you to get in there and look around at all the sales signs and so on. So there's more of a heightened standard for the store to anticipate that people will be looking at the products and not paying, it's not normal for people to walk around and just look at the floor. So the law does take that into consideration in those type of cases where it's a shopping situation.
And I know I have heard people say things like, well, just like you mentioned, Rick, like, oh, silly me, I should have been watching where I was going. But just like Rick said, that just because you didn't see whatever it was that caused you to trip does not necessarily mean that you don't have a case. There might have been something that existed there that shouldn't have been there, something that was dangerous that shouldn't have been. But I think that sometimes that does deter people from wanting to come in. They feel silly that they fell, or
Right.
That kind of thing. And there's no need to feel silly. It happens to all of us. And just because you did, doesn't mean that you may still have a case.
Now, Ian, you mentioned earlier this time of the year and holiday parties and things like that. If you're throwing a holiday party and it's privately at your house, what kind of precautions do you need to take so that somebody doesn't get hurt? Or if they leave afterward, if they get into some sort of an accident, are you going to be responsible for that?
Yeah, from a human standpoint and for a care standpoint, you want to make sure everybody gets home safely, and encourage Ubers and encourage ride shares. But the reality is where you could find yourself in a legal predicament is if there's underage people drinking at your house. And you can't use the excuse there's a big party and I didn't realize he or she was drinking. If you're serving alcohol and there's somebody underage that drank at your house, you're probably going to be on the hook at some level, or at least you're putting yourself in a dangerous position. So make sure you don't allow that. And in the old days, I think, let's just say things have changed a lot,
Right.
and you just can't do that anymore, and you shouldn't. And there's a reason, we don't, that underage drinkers shouldn't be drinking at your house.
Right.
Yeah.
Yeah, throwing a party, just have a quick safety plan. Have food for everybody. Have someone designated, especially a non-drinker, just to keep an eye on everybody. Have a plan. If someone does have too many drinks, how are we going to get them home? We put them in an Uber, or the non-drinker is going to be responsible for getting people home safely. It's real simple, and it's the standard of care these days. Safety's number one.
I'm going to run off to a break here right now. When we get back, we would love to take your phone calls. If you have any questions about premises liability, slip and fall, trip and fall accidents, things like that, make sure and give us a call. Don't wait to the very last minute to call in. Call in now. Phone number's on your screen. We'd love to hear from you right here on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. If you have any questions today about premises liability, we'll be happy to answer those for you. Here on the panel to answer those questions, we have from the McGuire Law Firm, Ian McGuire, also Brittany Jones, and from the O'Neill Law Firm, Rick O'Neill. So please call us. Phone number is on your screen, 848-8080. Before we went to break, we were talking about holiday parties at your own home. Well, holiday parties, if you go to some establishment or business or bar, or nightclub or restaurant, and there is an accident after that, is the business on the hook? Or what if they started drinking before they went to the party? Things like that. Does all that come into play?
Yeah, so that can definitely come into play if someone is in, it sounds like you're getting at, if someone were to be in an auto accident, maybe after they leave the party, that kind of thing, and they've been drinking at a party, whether at a business or somewhere, and the business or wherever it was that they were drinking definitely could be held responsible. We call that a dram shop action, where they contributed to the person's drinking or overserved them in some way, and therefore contributed in some way to the accident. And so there's certainly liability there.
And if the employee if this was in the scope of their employment, they were expected to attend this party, I mean, it can always be argued, it'd be up to a judge whether that claim would go forward, but that the business was somehow also contributed and is somehow a percentage at fault.
Yeah, and Rick could talk about, bartenders, they supposed to go through certain training, tips training, is that what they?
Right, the standard of care now is to do a formal online or in-person certification course for anyone serving alcohol at a licensed premises. And and that's just the beginning. That you have a manager on duty that's also supposed to be overseeing the serving of alcohol and making sure, again, safety's number one, and especially at holiday parties, we don't want anyone getting hurt over ending the Christmas season with a tragedy.
Yeah.
Now, we're probably going to be seeing a lot of rain potentially on this Friday, maybe all through the whole weekend. So if you're going to be going out to a store over the weekend, what is the store's responsibility to make sure that the environment is safe for you and all the rest of the shoppers?
Well, you have to prepare for things like that, have a safety plan again, but also notice the second big defense in these type of cases is notice that the premises holder or management knew or should have known that there was some dangerous condition. So that is a burden that's on you when you bring a claim, and that's either, it was just so obvious the employees, if just walking around, could have seen that the floor was wet, or that someone had notified management or an employee, hey, there's water at the front and it's flooding into the store. And then there's also claims a lot of times that are just a chronic problem. Every time it rains, water pulls up at this part of the floor in that store. Those things, the store is very arguably on notice, and when there's a problem, they should be taking care of it. And safety of the customer is number one. So,
yeah, and I would add to that, that's all absolutely, and those are the majority of the cases, but there's also cases where they create a danger. They mop the floor, and then they don't put signs up and they don't dry the floor, and then somebody trips or slips, and now they've created a dangerous condition, and clearly they would have had notice if you look at it that way anyway. But if once there's an undertaking and it creates a dangerous condition for people that are frequenting the premises, then they could easily be on the hook for that as well.
And all of it's going to go back to, what's reasonable in that situation. So that's like what notice is kind of getting to, or what, is it reasonable that they should have known that, that the floor was wet? If they're mopping, then yeah, they should have known that. They should have done something else. So it's always going to go back to that like reasonable factor.
And I see there's more litigation, at least lawsuits filed percentage-wise in those type of cases than there would be even in a car wreck. Car wreck, most of the time, the liability is not in question. As Brittany just pointed out, in virtually all the cases where they're on the premises, there's arguments both ways. There's very few that are just so clear-cut that there's not arguments to be made on both sides, and that's because the defense have sort of, as Rick alluded to earlier, open and obvious, and all these defenses that are in play that work for the defense. So most of these cases do end up in a lawsuit. It doesn't necessarily mean they go to court, but they proceed into discovery in a lawsuit. Much more so than a car wreck case would, for instance.
We talked about taking pictures earlier. I mean, video, a lot of the bigger stores will have video cameras up there. A lot of people will try to handle things themselves. I mean, are people able to get video themselves, or is that something they need a help of an attorney for?
Well, the attorney's going to send or hand deliver what's called a spoliation letter, telling the store that there's a claim pending and to preserve all evidence, especially videotape, because normally that's overwritten in a certain amount of time. It's almost laughable sometimes, though, that I find that when it helps them, they always are able to find video of the incident, and when it hurts them, all the cameras weren't working or the cameras weren't pointing in that section of the premises. But that's one thing, the video in this day and age with the digital evidence is something that you really need to get on ASAP without any delay.
Yeah.
Tell you what, we're going to run to another break here real quick. When we come back, we'll have just about 10 minutes or so to get you on the air. If you have any questions about slip and fall, trip and fall accidents, premises liability, that is our topic here today. Call us. The number's on your screen right here on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. We're talking about premises liability today. If you've been hurt on somebody else's premises and you want to know what you should do and what you shouldn't do, today's the day to call and get those questions answered. Phone number's on your screen, so don't wait any longer. We've got just a few minutes left in the show here today. Now, if somebody has been injured on somebody else's property, they can take care of that themselves without the help of an attorney. But if they try to do that, what are they missing out on without talking to an attorney and having them on their side?
Well, first and foremost, what an attorney can offer, and it's very important if you're going to actually hire an attorney or the firm that is going to take a case to court. Nobody wants to go to trial if they don't have to, generally as an injured person. But what a good attorney, a good firm can do is they'll have the artillery to take a case to trial, and it's the only thing that's going to get the attention of an insurance company. So, if you do it on your own, or you go to an attorney that's never going to go to trial, and the insurance company knows that, what's the risk for the insurance company? Their risk is getting that 12 people will look at the case and come back with a verdict that hurts the insurance company, right? So, not having an attorney, that's the first thing that comes to mind. The negotiation process, obviously, an attorney is, has an understanding of the negotiations because they're doing it each and every day. But to me, the biggest and most important reason to get an attorney, and more important than anything, is get an attorney that has a background or history of taking cases to trial, is going to get the insurance company's attention. And hopefully, that'll end up getting a case settled faster, because the insurance company will know, wow, if this doesn't get settled, we're going to go to trial and have risk. So
Yeah, otherwise you're negotiating from a point of weakness. You're not, you haven't put yourself in a good position to negotiate and get yourself a better settlement.
in other words, the insurance company is telling you what they're going to pay you,
Yeah.
as opposed to you having a say in all that, right?
Right.
I mean, you guys find that, a lot of these claims, initially, you get a letter and they're saying, we deny that we're liable at all, the claim is denied. You file suit, they may offer some small amount, but really when you get the fair settlement is after you've litigated it in that, like the mediation stage.
Yeah.
So it's a game they play, and don't be dismayed if initially they say, oh, you have no case, because a lot of times those cases, there is an offer, and then if you just wait it out and litigate it and gather the evidence, you can get a fair offer.
Yeah, absolutely.
Yeah, and I mean, certainly in this area, there's a number of good attorneys that would take case to trial if it's the right case to take to trial. And but at the very least, if you're injured, go talk to somebody. It doesn't even mean you have to hire the law firm. Almost any firm that's credible that does that type of personal injury work is going to have initial consultation where it's not going to cost anything. So take advantage of that at the very least, and then you can make a decision, a prudent decision of whether you want to hire an attorney or not. But
What's the final word? I know that you've gotten calls over the years about dog bites, and that's one of those, issues that people kind of like smile about or laugh about or maybe roll their eyes. But if somebody's dealing with the dog bite issue from a neighbor or just, whatever, how does that work?
well, I mean, dog bite cases are actually, they're essentially, you don't have to prove that the dog bit somebody before anymore in South Carolina. So
Yeah, that's an old kind of misconception.
And unfortunately, most of the time people bring dog bite cases because they've had a really bad experience
Yeah.
and bad injury. Whether there's insurance or not depends on the case, but the truth of the matter, from a liability standpoint, they're rather easy cases to prosecute, to go forward on. If there's insurance there. So I would certainly, and I know that's awkward. You have a neighbor and you don't want to have bad feelings, and that's all something, and which we talked about at the beginning of the show. If that's why if you have insurance, you're going to be covered, and it won't be you personally. I don't know. Thomas is calling. I don't know if we have time, Dave, to grab it or.
I must not be hearing anything.
Yeah. Well, Thomas. Gotta be quick.
Yes, I was doing some work on somebody's property and got hurt, but I've called several attorneys, and they say because I have diabetes that there's no lawsuit.
Well, what kind of, without getting too specific, what did the injury have anything to do with your diabetes?
No. What had happened is I had stepped on a drywall screw. And my foot had gotten infected, and I've ended up having to have my leg amputated.
Oh, I'm so sorry to hear that. The fact that you had diabetes should not preclude or prohibit your ability to go ahead with a case. We take a person as we find them. So I would not give up that easily. I think we got to run, but I would try to call another attorney and see what you can do. I think we're out of time almost, but I wish you the best.
Yeah, your injury's severe, follow up on that. There could be a workers' comp type of claim overlap too.
Yep.
All right, Thomas, thanks for calling in. Appreciate that, and thanks for taking that because I wasn't hearing it at the moment. But next week when we get back together, we're going to be talking about personal injury, which a lot of what we just got done talking about kind of fall into that umbrella as well. Personal injury is next week. Want to thank our panel here today, Ian McGuire, also Brittany Jones, and Rick O'Neill. Thank you for being there. I'm Dave Priest. We'll see you next Thursday, next edition of Legal Access, brought to you by the McGuire Law Firm.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may